بس يشتغل مؤخرا بتخصيص
Well, hello. Thank you all for coming. My name is Bruce Rich. I'm a visiting scholar currently at the Environmental Law Institute in Washington, and I am the chairman of this session this afternoon on environmental justice and energy development. By way of introduction, I might mention that I had a choice of the panels I could chair. There was quite a wide variety of panels, and this is the one I chose because I think it's really one of the most interesting issues currently, and has been for some time, concerning environmental law, governance, sustainable development, and civil society movements worldwide. I myself right now am writing a book on the World Bank and the environment since the Rio Earth Summit, and what becomes quite clear is that the whole issue of energy development, the environmental, both local and global environmental and social impacts, and the attempts to frame that development in some sort of framework of environmental and social standards is an ongoing issue in many places in the world, and there are many famous infamous controversies concerning these issues. Our three speakers today really cover a pretty wide ground in this area, and with covering, at least touching on a lot of very fundamental issues. The first, Brooks Ako, will talk about environmental justice in Nigeria's oil industry, recognizing and embracing contemporary legal developments. The oil and gas development in developing countries is a huge issue. There have been many notorious controversies around the world. The whole issue of extractive industries and social and environmental rights is a critical one. I myself followed very closely the development within the World Bank of the Extractive Industries Review, which was released in 2004. It was actually the World Bank financing of these big oil development projects in particular become so controversial that the bank saw a need to have a multi-stakeholder dialogue to develop some sort of framework of best practice with the bank and so on. That whole effort was chaired by Emil Salim, Indonesia's first Minister of the Environment, and who had also chaired the 2002 Johannesburg World Summit on Sustainable Development. That report came out with a lot of good recommendations for the bank and other financial industries. One of them, for example, was that the principle of free prior informed consent that's incorporated in, for example, in ILO Convention 169, also more recently in the United Nations Convention on Indigenous Peoples. The precise name of that convention escapes me, but it's an accepted principle, as you know, in public international law for quite a number of years. And the Extractive Industries Review actually suggested that the principle of free, prior, informed consent should be extended not just from indigenous peoples, but for all communities that are affected by extractive industries. There were a number of other recommendations, which the World Bank actually rejected. So there's so much for that. That it shows the difficulty. There was another huge bank finance project, the Chad Cameroon project in West and Central Africa. Hundreds of millions of dollars went in for it. An attempt to establish governance, revenue management, use of the revenues for poverty development. It didn't work. So we're looking forward to the talk of Brooks on this incredibly important issue to see what progress has been made. Second speaker will be Nathalie Chalefour from the University of Ottawa in Canada. She will be talking about environmental justice and the green economy, risks and opportunities. That really was a big theme at Rio. You had some people, some civil society groups who say that the so-called financialization of nature is really all in all, not a very productive development. If you think about certain areas of the green economy, let's take the global carbon markets and the clean development mechanism. There's been a lot of controversy over those. Clean development mechanism, for example, was supposed to deliver local social and environmental benefits under the Kyoto Protocol, and it almost relentlessly has not. It's only been a tiny number of the projects that the CDM even paid attention to local development benefits. Those of you who follow forestry issues, we have the RED Plus initiatives, which a lot of groups have been following as the last hope for forests, another example, if you will, for some of the green economy. But there have been large controversies there, particularly between some indigenous peoples and rights groups and the proponents of RED Plus over what role environmental and social safeguards, and particularly indigenous rights safeguards, should play in the development of RED Plus. So we're looking forward to Natalie to sort of give us some insights over the green economy. And is it just a financialization of nature and greenwash for the most part? Or would that be throwing the baby out with the bathwater, either more redeeming characteristics or not? And finally, the last issue is a hugely important issue over which Wilhelmine Duplessis from the Northwest University of South Africa will talk. She will talk about energy efficiency, new strategies for improving African energy laws. Well, South Africa is a country endowed with large coal resources. There have been huge controversies in recent years over the international finance of giant coal plants in South Africa, to the 4,000 plus megawatt Medupi plant, and then another 4,000 megawatt Kusile plant that have been financed in recent years. The first one by the World Bank and the African Development Bank and other donors. The second one by various export credit agencies, including the U.S. Export-Import Bank, the French COFAS, German KfW, and so on. Those two coal plants will be two of the 50 biggest point sources of greenhouse emissions on the planet for the next 50 years. Yet South Africa desperately needs energy. There is a way out of the need to build a lot of new energy infrastructure. It's through investments in energy efficiency. I myself have followed this issue for 2 decades. There have been a number of reports that have identified energy efficiency as one global win-win solution, a least cost solution that's also environmentally most beneficial, are innumerable. I'll just cite the International Energy Agency, which in 2010 said that 89% of the needed greenhouse gas reductions on this planet could be achieved through joint investments in energy efficiency and renewable energy, split approximately half between the two. The World Bank's Independent Evaluation Group recently wrote that 20% of all the greenhouse gas emissions on Earth that would be needed to avoid dangerous global warming could be achieved by investments in energy efficiency in developing countries, which would more than pay for themselves, and so on and so forth. Yet the obstacles to energy efficiency have been huge. The bank has actually done relatively little in this area until recently, and in many countries there are huge institutional and governance obstacles to achieving it. So it'll be fascinating to hear what progress there is in South Africa in this regard. Well, I've, following the model that the job you can't abuse is a job not having, I've abused my role as chairman of the panel a bit too long, but we're looking forward to a lively discussion. I would ask the panelists to try to limit their presentations to 20 minutes, because we could have a very interesting discussion among ourselves afterwards for the remaining 30 or 35 minutes. And this is the 4th day, so it's more fun just to have a lively discussion, just to have everyone talking. With that note, I'll keep my mouth shut and invite Luke to give the first presentation.
Thanks, Bruce. You've made my job certainly easier.
Okay.
Because
no egos unpunished.
But it's great to be here to talk to you guys today, and thanks to everyone who's done something to bring us here together. What I'm going to be talking about today is environmental justice in Nigeria's oil industry, and what I want to do in the 20 minutes I've got is sort of highlight some thoughts I'm having presently on the situation in Nigeria regarding litigating more with regards to the oil industry. Just to give a background, I started thinking about this because I'm consulting for Friends of the Earth in a case that is going on in the Netherlands as we speak. And just as is typical of litigation, you know, when oil industries are involved, at least in Nigeria, there tends to be this notion of looking for any means necessary to frustrate the plaintiffs. So what happens is issues of legal standings tossed, issues regarding and whether the villages and so on, you know, really the faults of the oil companies are tossed out there. So what I'll do before I get into the paper is to just give you very briefly facts of two cases. The first one is ongoing in the UK, that's Obodo and Shell. And this is a case where Shell has actually admitted liability for oil spills for about 2-3 decades ongoing. So it's there, the spills are there, Shell accepts that the spill is theirs. They've tried to negotiate settlements that haven't worked, and they're in court right now. So just to remind, all I'm trying to do is just to give you issues regarding litigation. And one of the primary issues Shell has raised at litigation, first day litigation, is the community doesn't have legal standing because it's not a legal personality. So yeah, the spill is ours, but they shouldn't get anything because they're not a person. The other case is the one I'm more directly involved with, is Akpan and Shell, and that's ongoing in the Netherlands, as I said previously. And Friends of the Earth Netherlands is involved in this case, and actually joint plaintiffs. And the counsel for Shell, who is Hassan, that's the senior advocate of Nigeria, that's the highest gas practicing lawyer in Nigeria. And at the same time, the Queen's Counsel in the UK, which means, hey, he must be smarter than all of us in that maybe. But guess what he says? Friends of the Earth doesn't have legal standing, when expressly there are laws in Nigeria that have changed. Okay? So yes, if he had said this before 1999, fair enough. But since then, things have changed. So it got me thinking, if a SAN and QC, however dubious his intentions might have been, or genuine, still doesn't know that things have changed, then what's the hope for the lawyers who typically represent these communities? Because, again, to give you a brief picture, the community lawyers are basically, more often than not, people of that community who've gone to the law school, who see these things, take on the cases, don't charge anything, and it's like, we win it, I get my percentage of, So again, it's not an expert law firm, so to speak. So my thinking was, if people who should know these things don't know it, what more? And this is a project that is going on, and hopefully with comments, questions, insights, I can develop this to what I want it to be at the end of the day. Just background for those who don't know the Niger Delta, that's where most of the oil exploration takes place in Nigeria. The legal framework, in our opinion, is the main driver of conflicts, because law is, in my opinion, the main regulator of society. If it fails, then society itself fails and goes into anarchy, and that's what I think has happened. Many other people will tell you it's basically economics, politics, but my argument is law determines all these things. There's an amnesty initiative, which basically was an offer by the government to militant groups to give up violent names, and in return promise to educate them, send them to schools and so on. And so far, that's recorded some success. I'm sure fuel is probably, you call it gas. Gas is probably cheaper in the US now, as a result. But again, as is usual with governments around the world, in most cases they see a little bit of success and they forget that there's really something fundamental that caused the conflicts in the first place. So The legal framework remains the same, and nothing has been done or has been done to have a rethink on how this has precipitated or exacerbated conflicts in the region. Now, what I'm going to talk about now are the recent developments in Nigeria, and by recent I mean from 1999, when Nigeria returned to democratic governance, and that's why I call that democratic dividends. Obviously, democracy signifies constitutional supremacy. That's quite basic. And what that has done in Nigeria with regards our topic today is that it's made the fundamental human rights charter effective. So all fundamental rights can be enforced in courts of law. Under the military regime, I mean, it was usually ousted by military decree. That was the first thing they did, seize power, roll out a decree to ensure that no one has fundamental rights. So, yes, in America that might seem quite basic, quite, you're born with it and everything, but in that part of the world, it's not that straightforward. I've given an example with the Land Use Act to then say it's no longer a superior law, it's just any other law, even though it still has, it's attached to the Constitution, so it's still above other laws. And the Land Use Act is significant because what it does is, if you look at the third thing, what the Land Use Act does is it actually ousts judicial jurisdiction of courts, because one of the things the Land Use Act does is to actually provide that the Land Use Allocation Committee, which is like an administrative body, should determine issues that arise from the Land Use Act, so that's like compensation, land use, and all of that. Secondly, it also locked opportunities to go to the regular courts. That's what I mentioned earlier. So what constitutional supremacy has done now is to ensure that the Land Use Act is no longer seen as a superior law in Nigeria. The other development is FREP, which is the Fundamental Rights Enforcement Procedure Rules. And what FREP has done is to actually simplify the law on standing. If given a brief history of standing in Nigeria, it's been a mess with all the courts from the high courts all the way to the Supreme Courts giving different interpretations and decisions on the principle of legal standing. So what FREP has done is to actually simplify it in Nigeria now. And one of the important provisions is the third preamble, which actually refers to respect for municipal, regional, and international bills of rights. And it expressly mentions the African Charter in preamble 3B1. Now that's very, very important because don't forget we're talking about environmental justice, and in Nigeria, the fundamental right to the environment doesn't exist. So, in my opinion, if the preamble refers to these international laws and specifically lists the African Charter that recognizes the right to environment, we can then say we can utilize the FREP rules to advance environmental litigation. Preamble 3E just tells us who can litigate or who has legal standing, and there are 5. That's anyone acting in his own interest, anyone acting on behalf of another, anyone acting as a member of or in the interest of a group or class of persons, anyone acting in public interest, and an association acting in the interest of its members or other individuals or groups. So if you look at that, for instance, you wonder why the SAN and QC would argue that Friends of the Earth, for example, doesn't have legal standing. Now, it's also interesting to note that in responding to his legal opinion, when I pointed that out and listed a few cases. They asked the court for time to do a response. I'm still waiting to see that, but I'm sure, it's going to be something different. So time will tell on that. Now, the third one is not so much a legal development as such. It's more of, I think, something that can help with policy. And I'll just take you back to remind you that, again, my thesis is based on law being the fundamental driver of conflict. So in my opinion, if the laws are set right and then, of course, the enforcement mechanisms are there, then the conflicts will certainly reduce. In Nigeria, there have been attempts to hold all sorts of talk shops on the way forward with the issue in Niger Delta. None has succeeded. And I just thought to myself, the UNIPP stands for the United Nations Indigenous Peoples Partnerships, and it's new. And I thought, hold on, if you look at the terms of reference of this body, you'll find out that it's something that can benefit places like Nigeria and several other places with indigenous populations who are being exempted from participating in the management of the environmental resources. And there are two key things that the UNIPP strives to do. The first is to develop capacity towards realization of indigenous people's rights in line with the UNITRIP and ILO Convention in one or more of these themes: legislative review and reform, which in my view is the main issue in the Delta; democratic governance and indigenous people's institutions, which I think is also going to help, because again, it's these indigenous people's institutions like MOSOP, for instance, which I think we'll be more familiar with, that have been at the forefront; access to justice, which again is the main theme of what I'm talking about; access to land and ancestral territories. Remember the Land Use Act I spoke about; and natural resources and extractive industries, which again embodies the whole conflict, which drives the whole conflict process in the Delta. And then the second thing the UNIPP seeks to do is to promote consultative mechanisms and participatory processes with the state. In other words, it gets the state and those involved together and seek to resolve this through dialogue. Of course, they've rolled out the first set of countries that will be involved. There will be about, I think, 6 countries now. And what I intend to do is to actually do a bit more research and see how UNIPP selects what countries to operate in, and then begin to see how one can collaborate with community-based organizations, NGOs, and perhaps the state in Nigeria to see how the Delta can also benefit from the activities. But of course, there's a fundamental thing that qualification, and that is the Niger Delta people must be recognized as indigenous peoples to actually benefit from that. And that takes us to, do they actually qualify? Now, the parameters to benefit or to be classified as indigenous people include these factors. First, the claimants' groups and cultures and ways of life must differ considerably from those of the dominant society. In Nigeria, the Niger Delta is the 4th largest group, but is considered a minority in the country. The 3 major groups are the Igbos, Yorubas, and Hausas, and their cultures differ. Secondly, their cultures must be under threat, in some cases on the verge of extinction. I mean, of course, I knew there won't be time to go through all of this, but again, the charters of all the groups in the Niger Delta reaffirm that they are indeed under threat. The Constitution doesn't recognize any of the minority languages and other factors. Survival of their particular way of life depends on access and rights to their traditional land and resources. The people in this region are basically farmers and fishermen, gatherers, hunters, and obviously they do need their land and resources, which they can't get access to mostly because oil exploration is land intensive, and the law is also there to ensure that these multinationals can actually go and take land if they need it. The Land Use Act stipulates that if land is required for any activity or related activity, you should have it, basically. They often live in inaccessible, geographically isolated regions. Again, the Niger Delta is made up of different ecosystems. Most of them live in creeks, and one of the reasons that the government gives for the undeveloped state of the region is that they don't have access. So again, ticks that box. It also says they must suffer from political and social marginalization and are subject to domination and exploitation within national political and economic structures. Again, that's something that is a characteristic of the region. Again, because they are a minority both culturally and numerically, they have not been able to make any significant contribution to national political and economic decisions. Of course, now people argue that the president is from the region, but you know that in itself doesn't mean he's got access. I think that was a mistake that happened. It's a result of a lot of political calculations that we need not go into. But even at that, the fact that your president doesn't mean you can wake up and do things. There are democratic structures that are in place to ensure power is not abused. So what I've done, just to recap, is just to highlight the environmental injustice situation in the Niger Delta and look at situations, recent developments that can make a change. Again, this keys in with one of the, several of the speeches from yesterday, that what we need to do is to actually look at extant laws, policies as they are, and look for innovative ways to work around them. There's no point, sitting and not doing anything, thinking, oh no, they need to review laws, otherwise nothing's going to work. Things work around the law. Where lawyers then to start thinking innovatively and start sort of relating with people on the ground, NGOs, local legal practitioners, academics, and I think it's through this way that we can all achieve that common goal we're striving for, which is environmental justice. So I'll stop here and hope that there will be contributions to helping others.
It was great, 19 minutes. So. Natalie will speak now. I guess I would ask everyone maybe to write down questions they might have for each speaker, and then at the end we may have a nice open discussion with all of them.
Good idea. So, nice to see you all here at the end of the day. It's kind of a tough spot to speak in, but appreciate everybody's attendance, and hopefully you've got a little bit of caffeine or some oxygen or something. So what I'm going to speak to you about today is evidently environmental justice and the green economy. And I'm going to begin by stating the obvious, which is that sustainable development is a paradigm. Hasn't been working yet. We're all aware that environmentally we're depleting our environmental capital at a far greater rate than we should be. But socially, we live in a world where some 2.6 billion people don't have access to basic sanitation. Some almost 1 billion people lack access to safe drinking water, and the same amount of people are essentially undernourished. And economically, while we've actually quadrupled the economy in the last quarter century, we've done that on the back of fossil fuels and natural capital, and we know that we're in the midst now of a financial crisis, so even the stalwart pillar of sustainable development may in fact be in some trouble. Now, activists and scholars and a number of people for some time have been talking about green economic instruments and the market economy, the greening of that as a way to potentially reconcile the environment and the economic pillars of sustainable development. And in fact, I have been working on market instruments and environmental taxation for quite some time, and I'm a big fan of this idea. But it increased in terms of its magnitude when it became a major theme at Rio +20. And so what's happened now is that the question has become, can and should the green economy be a mechanism for also advancing social justice and environmental justice goals? Traditionally, green economic measures haven't been part of that. They've really been about trying to do achieve environmental effectiveness at a lower economic cost. But now, given the emphasis on the green economy at Rio, the question has been posed, and the answer, I think, needs to be addressed. So that's the question that essentially my paper is going to be addressed. I want to make it clear that I think the green economy shouldn't be the primary mechanism for achieving environmental or social justice. That is clearly not the case. We have to have a basic set of environmental human rights and do that independently of this. But at the same time, given that all of this global energy is going into now the greening of the economy, which again is a good thing in many ways, I think we're obligated to look at doing so in a way that at minimum doesn't exacerbate existing systemic inequalities that exist, and ideally would actually be synergistic in terms of promoting it. So my paper is going to just briefly go over what the definitions are, because we can actually talk in circles about both environmental justice and the green economy, and if we don't actually be precise about what we're talking about, it might be a bit counterproductive. The main bulk of my paper and the talk is really on the tensions and synergies. And what I've done is I've done two things. I've tried to identify some strategies that come out of the literature, some of which I propose and a lot of which are actually proposed in the literature and which I've picked up on, for actually integrating these two goals. And there's a lot of literature that shows that they're not always integratable, if I can say that, but that there are some strategies for increasing the synergy between the two, and then look at some actual specific tools and strategies to see how they pan out in terms of an ecological justice or an environmental justice perspective. So in terms of the green economy, I think everybody has a general idea of what it is. There's no one single definition that's kind of universally agreed on, but there's a number of key principles. So things like internalizing negative environmental externalities, decoupling economic growth from resource use, acting within the Earth's carrying capacity. These are things we're all familiar with, I would imagine. Adopting new measures of progress, having a more systems-based, holistic approach, strengthening resilience and reducing vulnerability, and ensuring fairness and equity. So actually this definition takes into account the social justice perspective. And similarly, UNEP in its primary document with respect to the greening of the economy at Rio +20 also had what I think is actually quite a beautiful definition of the green economy that very much brings environmental justice into the forefront. The devil is always in the details, and it's in fact, I think, when we get down to the tools and strategies of the green economy that the more sort of utopian effort at bringing social justice into the green economy may fail. And this is where we look at what some of the actual tools are. Because I want to keep my talk short enough and not go over my 19 minutes, I want to just go through this quickly, but you know what the tools and strategies are. I would think writ large, we're talking about taxation policies and fees to increase the price internalization, elimination of perverse subsidies, creating property rights regimes, research and development for green technology, green procurement. Governments are actually major purchasers of the world, some of the major purchasers in society, so we can actually do a lot for that. Number of the tools. As Bruce said as an introduction, there's a lot of positive energy towards the greening of the economy in the lead up to Rio +20 and at Rio +20, but there was also a lot of concern that was raised, and I borrowed from a number of documents as well in terms of what the developing country perspective. People raised concerns. Is this just another pretext for green protectionism that's going to hinder economic development and exacerbate inequalities? Bruce again referred to some of the controversy that's come up with things like REDD+, which there's been a controversy in Uganda with regards to potential for land displacement, and some are concerned that this is just going to further these problems. So the question, as I said, is, are green economic policies going to exacerbate these inequalities that already exist? So turning then to environmental justice, I think most of you probably know environmental justice is a movement that emerged in the 1980s, mainly in the U.S., out of concern that toxic sites and environmentally harmful areas were being located disproportionately in poor racialized communities. And there are now empirical studies emerging from all around the world that document this, that show that the less affluent people in society bear, on average, greater burdens of environmental harm, usually in the form of environmental health impacts, than their more affluent counterparts. And my paper has quite a bit of the data coming from that. And the very often cited definition of environmental justice comes from actually the US EPA, and I put it on the screen there for your consideration. As the definition of often environmental justice focuses an awful lot on income, but actually there's a lot more to it. And I've done a little bit of research on environmental economic instruments in women and economic instruments in Indigenous peoples, and that pushing us to look a little bit more at not just the income impacts, but also other vectors of inequality and vulnerability in society. And again, in my paper, I've got quite a bit of research looking to see that it's not just about income levels, it's often income plus other factors, such as women playing socioeconomic roles in society, Indigenous communities and their vulnerabilities and particular impacts, children, seniors. Unless we think this is just an issue in a developing country context, this is an issue in a developed country context as well. I'll give you just one statistic. The Hurricane Katrina, which hit the city of New Orleans in the US in 2005, 80% of the people that were left behind in the wake of that disaster were low-income racialized women. They were left to deal with the issue. And again, just the last point on environmental justice that I'll make before moving on to the crux of the talk is that most of what I've said so far has been about distributional impact and the question of who bears the environmental burdens and harms in society of our decisions related to the environment. But there's also a lot to be said about the role of participation in decision making, who's included in the decision making and who's not included, and the question of recognition. To some of our approaches, perhaps our myopic focus on GDP and economic growth, for instance, or our largely wealthy, often white, often male decision-making and institutional structures devalue some people's place and identities. So, again, I'm going to go through a few of these slides. I have an awful lot of slides, so I'll stick through them. Can the green economy be advanced in a way that advances these three goals? Sometimes when I've done versions of this talk or previous versions of the paper that evolved to this one, people say, well, again, it's not about, the green economy is not meant to do this. This isn't about social justice. Keep them separate. Let the human rights movement deal with the social justice, and let's deal with efficiency. But I think that's, so the question is, should the green economy be used in a way that advances environmental justice? And I think that yes, and my argument is that we can be smart. It may not be the primary tool of environmental justice, but we can be smart about how we design green economic tools, and we have choice, as I will argue in the next half of my talk, that we can actually design instruments that are either neutral or favor environmental justice goals, or we can choose to be willfully blind and forge ahead with strategies that are going to further entrench and deepen existing inequalities. And I think the facts are compelling for the smarter approach. I have quite a few statistics, again, in the paper, which I'm not going to go through in detail. Just to point out that there are two parts of this puzzle, which is the overall poverty issue, but also the increasing inequality. And the inequality, of course, is growing very, very rapidly between countries, but also within countries. There's a recent piece of research that, again, is in the paper. I don't have it on the screen. It shows that the rate of inequality within countries is growing in 96% of countries. So only 4% of countries have managed to actually reduce internal inequality. And that in terms of the concept of accountability and responsibility, again, there's a lot of research to show that people with lower incomes have smaller ecological footprints, not surprisingly, and same thing with countries with lower GDPs. And here are just a couple of case studies that I pull out again that are featured in the paper, one of which I pulled it out because it has a rather startling percentage, but individuals in the top income decile in Israel case study here are responsible for per capita emissions 25 times higher than those in the bottom decile. Again, just another statistic. I always like to be sort of reminded of the startling statistics we're working with to motivate the work, but we know that the world's poorest 20% consume 1.5% compared to the world's richest, and just to make this a bigger challenge, up to 3 billion more middle-class consumers are going to emerge in the next 20 years. I think there's many arguments for why we should actually be doing this the smart way. So let's talk about now the how, right, which is the main element. What strategies exist then to actually try to design a green economy and mobilize it in a way that is synergistic with environmental justice goals, and which strategies are more amenable to? First of all, I think the right definition is really important. And I think we missed a huge opportunity at Rio Plus 20 to actually agree on a definition of the green economy that is inclusive. There was no official agreement. We do have the definition in the UNEP document, so that is the one that's being bantered about, but there was no actual agreement, and there was no opportunity to develop a set of principles that would actually help us guide in the right direction. I also think, as I've said before, that we have to always keep in mind that this has to be done in the context of an equally robust effort to develop a set of basic human rights for all. So, in terms of one of the key tools, I think information is power. And in the environmental movement, we know that at some point, 4 decades ago in the US, environmental assessment legislation was passed. And that became an extremely powerful and useful tool to inform decision making. And there have been movements, and there's actually some writing from a Canadian colleague of mine, and Robert Gibson, which is fantastic on this issue, a push to move towards sustainability assessments that would include some of the analysis of social issues. And I've called them here in my research vulnerability assessments. The point is that we have to be looking at who is vulnerable, who is being impacted by which environmental harms, and so that we have the information upon which to base our assessments of how we're going to move forward. And so that I think we need to be doing this as a matter of course, whether it's with environmental impact assessment or in a separate process, it's really a question of procedure. But I think doing those assessments is absolutely critical. Relatedly, data gaps. We can't manage what we don't measure. We all know this adage, it's true. So what are we measuring? What are we not measuring, perhaps more importantly? I think that we are often, again, the context of people developing green economic tools, often not getting the information we need to actually make wise decisions, and not measuring allows us to keep our blinders on and blunder forward in alleged ignorance. I think we have to redefine progress and wealth. Again, these are not my ideas. I'm recapitulating a lot of ideas that have been said already, but I think that's really key to environmental justice. We have to actually take the emphasis off GDP as the single measure of progress in society and actually put some serious effort behind some of these alternative measures that can actually help us to see if we're making progress or not. And to also create, a sense of our vision for where we're going and what we want to be what do we want to be motivated by? I mentioned the procedural aspect, and this is really key. Enabling full, meaningful participation of all communities in decision-making is huge. Who's at the parliamentary and the legislative table in our various countries? Globally, only 19% of women, again, I've done some work on women, so I use that as a statistic, are parliamentarians. And lest you think that's an issue only for some countries, in Canada we're only at 22%. Who is at the boardroom table? 17% of boardroom appointments in the London Stock Exchange are women. Again, I'm just giving you those statistics because they're the ones I have. If you did it by income, I think the statistics would be more startling. And again, in Canada, only 2% of CEOs are women. Who's at the delegation of the various international meetings that we're going to? In 2008, the delegations of the United Nations Framework Convention on Climate Change meeting of 46 countries did not include a single woman. And lest you say again that, and I've heard these arguments before, what does it matter? Because whoever you have there can represent different interests other than their own. That certainly is true. That said, there's interesting research that shows a correlation between developed countries with higher proportions of female representation and success in reducing CO2 emissions. I found that really interesting. Okay, another piece of the puzzle, which again I think is hugely interesting, and I didn't put these in any order of priority, is conducting systemic analysis of existing and future regulatory and policy and funding initiatives for their impacts on the poor and disadvantaged groups. So knowing what the distributional impacts are. Who benefits from tax cuts? You have to pay taxes to benefit from tax cuts. You have to file a tax report. Who's benefiting from the spending initiatives? If you're proposing incentives to retrofit homes, homeowners are benefiting. Who are the homeowners? Those are the kind of questions that I'd like to see us posing before and during the process of choosing and selecting instruments. So now in the last 3 or 4 minutes, I'm just going to go through quickly a couple of, or actually a series of measures. My paper does it in more detail, so I'll do it quickly here. But I've given green and yellow lights. I didn't give any red lights because, again, I think we do have to move in the direction of the green economy. I'm not here to oppose the green economy. I'm here to try to promote doing it in a wise way. There are some strategies that are they're better from an environmental justice perspective. And the first thing to mention is that because the poor are more vulnerable to environmental impacts, any strategy that helps reduce environmental harm is going to have a good impact on on vulnerable communities. So that's something that we have to keep in mind, sort of as a baseline thing. Investments in public transportation. I give these a green light because lower income and minority groups often are more reliant on public transportation. So if we're thinking about greening the economy and in the suite of measures we can consider, this is one that I think has a nice synergy between the three pillars of sustainable development. But we have to take care because, again, at the level of detail, there's a case study that demonstrates that in Manhattan, 5 of the 6 public transit bus depots are located in racialized low-income communities, which is leading to disproportionately high levels of illness and disease among those communities. So we have to be thoughtful at all levels of how we do this. Payments for ecosystem services, of course, we all know, I think, what they are. And thankfully, recent empirical data has showed that they can be effective in reducing poverty, because there were some concerns at the beginning that maybe they were going to be, not the best tool for poverty eradication, but there's more than this in terms of the research is showing to be actually quite a promising initiative. The only caution is the fact that obviously they're available primarily to landowners, and small landowners may have more difficulty participating, but still, they get a green light from me. Price corrections. Why aren't these getting a red light, given that when you increase prices, obviously the people with less income are going to have more difficulty coping with those. They are regressive as a rule, but they're really key to the transformation of the economy. We have to raise prices and we have to internalize externalities. So the good news, and I've got a couple pieces of research that show this in the context of Indigenous people and women, that they can be made fair if the instrument is designed properly. And so they have to not only look at the impacts of the cost of the measure, but also how the revenue is used and how it's redistributed. And I done some research on the British Columbia carbon tax, which is now up to $30 a ton. And it's revenue neutral in the sense that all the revenue from the carbon tax is recycled back into a series of tax cuts and a low-income tax credit and a few other measures. Alone, the carbon tax is regressive. At the beginning of the carbon tax, it actually went from $15 up to $30. At the beginning of it, it was actually okay for low-income communities because they gave a lot of it back in the form of a refundable low-income tax credit. So even if you didn't pay taxes, you were still getting the credit. But they didn't keep the low-income tax credit rising at the same rate as the carbon tax. So now it's become, I'll show it in this now the lowest quintile is paying $15, whereas the highest quintile is getting $212 from the carbon tax when you take into account the tax cuts. So it started out good, and now it's a little bit problematic from an environmental justice perspective. London's congestion fee, and I know I'm just about out of time, so I'm almost at the end of my list here. London's congestion fee was introduced, again, a sort of a fantastic measure from an economic instruments point of view. It's very successful in reducing traffic in the downtown core, raising revenue, and there's good exemptions for people who residents and for emergency vehicles, alternative fuel vehicles, but nothing for low-income communities. There is a provision for disabled people, so they have taken some of the equality factors into consideration, but nothing for low income, and it's received a lot of criticism for that. They could have done that. Resource efficiency is a big one because, of course, it's just logical to increase efficiency, and it should be beneficial for everybody. And certainly in communities that depend on resources for heat and cooking and building, etc., it just makes sense to be efficient. The only caution I put here, and the reason it's a yellow versus a green light, is that we have to be careful of what's called the rebound effect, or Jevons paradox. And if you make something more efficient, are we just going to increase consumption? So we have to be very thoughtful to ensure that the gains that we get from resource efficiency are redistributed in a way that is equitable. All I'll say about harmful subsidies, absolutely we have to deal with this, but we have to take care that the people who are impacted, the sectors that are going to be impacted, and those jobs that are going to be lost, that there's transition strategies, unemployment insurance, etc., retraining. Property rights regimes are a big one, and I'm out of time, so I can't talk about it, but there are really, really strong distributional issues relating to property rights regimes for obvious reasons. If you're allocating property rights, who is getting those property rights? Who is getting the benefits from them? Very, very, it's not a red light because, again, it's very important from an environmental perspective. They're very economically efficient, but we have to be very careful with these. And I have, in my paper, quite a bit of research that shows that property rights regimes can be quite worrisome from the perspective of gender for women. Same thing with biofuels. I'll leave it at that and conclude that basically I think, as I said, that Rio Plus 20, we missed the golden opportunity to help advance sustainable development by defining a socially progressive definition of the green economy and identifying principles for ensuring it's harnessed in a synergistic way. So the fate of our sustainable development is right now back in the hands of civil society and our local and our state and national governments. And I think we stand at a fork in the road. So, you know, I think that I don't want to see us sitting here in another 5 or 10 years in the midst of a massive social crisis. And we talk about technological leapfrogging on a regular basis, and I think we should do some policy leapfrogging to get this right. That's all I have to say.
Well, speaking of the green economy, Wilhelmine and Duplessis will now talk to us about a very important issue with energy efficiency in South Africa. And energy efficiency, again, being one of the biggest ways to apply to
Thank you. To my set is excuses, but he also has a paper in one of the other sessions. He's very energetic because he's working on renewable energy and he's speaking in 3 sessions on renewable energy. I'm very excited about it. The dilemma, the Millennium Development Goals stress the necessity of changing the harsh reality faced by many people. Access to energy services can play a role, both direct and indirect, in the achievement of these goals, whether through facilitating economic development that assists alleviating poverty, or in empowering women and enhancing educational opportunities by reducing the time spent on basic survival activities such as gathering wood, as already said. But modern renewables that are still under development in wealthier economies may be quite unsuitable in developing ones. And where the problem is basic energy poverty, then energy efficiency may well have a role, but the fundamental need for energy sources must still be there. Now, renewable and energy efficiency are usually seen as 2 pillars of sustainable energy policies. Renewable energy usually deals with the supply side of energy, while energy efficiency deals with the demand side of energy. Barton in 2008 were quite pessimistic when he said that energy efficiency is often treated dismissively. He says that it's not as exciting as new sources of supplies, the great engineering ventures of ultra-deep water oil exploration, or returning to nuclear. He says great hope is pinned on the extension of renewable energy sources, in spite of the environmentally unpleasant trade-offs that they often demand. And he says it's paradoxical that energy efficiency is often the poor relation of the energy policy. At Rio Plus 20, a report was released by UNEP, JEF and the IEA, where they said that yearly savings in phasing out incandescent bulbs and other simple changes could amount to around 5% of the global energy consumption, and it could reduce worldwide output in CO2 emissions. For example, that will be equivalent to about 450 coal-fired power plants and more than 122 million mid-sized cars. The South African energy laws developed, as Bruce said, in a country heavily dependent on fossil fuels. There are various policy measures, commitments towards renewable energy and energy efficiency. Our energy efficiency measures that were introduced were initially introduced due to economic rather than environmental concerns. There are various measures that are taken in South Africa. There are solar and wind farm projects in the northern and western Cape. We have introduced voluntary energy efficient measures such as the newly ISO 50001 measures and other voluntary standards in our legislation. But we also have the expansion of coal-fired power plants, as Bruce said, as well as expansion of our nuclear facilities that Michelle can tell you more about it. The argument is that South Africa should not immediately abandon cheap and abundantly available fossil fuels because we still need a lot of economic growth. Our energy efficiency and renewables are introduced by various policy papers and by various pieces of legislation that I will deal with. The aim of this paper is therefore to discuss the new strategies to improve South Africa's energy laws with reference to energy efficiency and renewables, and I will then refer them to the policy, the legislation, voluntary measures, and to the references to challenges and successes thereof. First then, with regard to energy efficiency. What is energy efficiency? Our National Energy Act says it's the economical and efficient production and utilization of an energy carrier or resource. And the discussions around energy efficiency usually relate to energy efficiency in buildings or technology or transportation, etc. Renewable energy is usually defined with regard to the sources. If we look at the definitions of energy carrier and energy resource in our National Energy Act, we see that it can be interpreted to include both non-renewable and renewable forms of energy. And we can say that energy efficiency would therefore relate both to renewable and non-renewable sources. In some sectors, the introduction of renewable energy is seen as a way to become more energy efficient. But the specific renewable energy technology must, however, itself also be energy efficient during its own life cycle. Sometimes the energy efficiency of renewable energy carriers is not discussed within its own life cycle, only the net benefits of it celebrated. Our energy efficiency is regulated by our Department of Energy that established Energy Efficiency Directorate, and it's also then on the local level dealt with by our municipalities. In 2009, we've published the National Energy Efficiency Strategy, which aims to minimize the negative effects of energy usage on human health and the environment. And it set targets of 12% energy efficiency improvement for 2050. There was also individual targets set for different sectors of the economy. Various tools were also proposed and said that government will introduce them, namely economic and legislative measures, energy labelling, standards and audits, and energy management. Government buildings were in the meantime retrofitted with efficient light bulbs, and they saved 600,000 rand just on energy bills, and they encouraged municipalities to introduce new measures. Our Electricity Regulation Act said that the minister may prescribe which energy mixes must apply, and also he may or she may introduce energy efficiency measures. In 28, regulations for compulsory norms and standards for reticulation services were also published, and it dealt with street lighting, electric water heating, space heating, swimming pools, etc. Our Electricity Regulation Act also provides for demand-side management. Now, demand-side management can improve energy efficiency and render unnecessary the construction of new generation capacity. South Africa has to move towards a resource mix in which renewable energy sources play a greater role. But this can only happen if the policy and legal framework is facilitated enough. We've seen a few examples where demand-side management measures have also already been implemented. The university in the Nelson Mandela Metropole and the municipality has already introduced some small-scale renewables and use it in the municipal grid. The time of use tariff pricing forced several industries to limit their energy use during peak hours and to introduce energy management practices. And some industries even had to introduce new technology and software to ensure that their operations stay economically viable. In terms of our National Energy Act, the Minister may also issue regulations pertaining to energy efficiency, whether it deals with labelling or standards or whatever. She has a long list to keep her busy. In 2011, regulations on the allowance for energy efficiency savings were also introduced. And industry or individuals may now claim a tax allowance for energy savings if they can prove that there was energy savings. This must be determined by a person who is a measurement and verification professional, and the baseline energy consumption must be determined in terms of ISO 50001. And the measurement and verification must also be done in terms of ISO 50001. It's a linkage of a voluntary mechanism with a legal instrument. Now, what is this ISO 50001? It's incorporated in our South African National Standard, SANS 50001. It was published in July 2011. It provides for the implementation of the voluntary international ISO 50001 standard by organizations in South Africa. And it's used to improve their energy performance, etc. And its aim is to lead to the reduction in greenhouse gas emission and other related environmental impact of energy costs through systematic management of energy. Where did it originate? Since 2000, the US and Denmark introduced environmental management standards. A few other countries followed. UNIDO raised it with ISO, and ISO introduced it finally, ISO 50001 standard in June 2011. South Africa followed in July 2011 with the standard. The ISO 50001 standard is based on the Climate Change Act. The idea, you conduct an energy review and establish a baseline energy framework, then you implement your plan, you monitor it, and then you take actions to continually improve it. Now, ISO 50001, or the measurements at least prescribed in ISO 50001, is already incorporated into the tax legislation. Government indicated that it will conduct energy audits and that would play an important role in our energy efficiency strategy. And it's foreseen that ISO 50001 methodology would also be implemented by way of legislation to achieve this goal of government. Government also introduced in 2011 national building regulations dealing with energy use in buildings and energy efficiency in buildings. Previously, this was also a voluntary standard, and now it's now made compulsory in legislation. The one standard says what needs to be done, and the other one says how it should be done. Now, what do we see? We see that voluntary standards are now incorporated into legislation to assist government in achieving their energy efficiency standards. It seems that individuals in the industry will no longer have the luxury to choose whether they would follow the energy efficiency option, but they will have to comply with the standards. If they want to reap the benefits, of course, they have to comply with ISO 50001. As energy efficiency measures are highly technical, it's foreseen that government will in future incorporate more of these type of standards into its legislation. With regard to renewable energy, energy efficiency and demand-side management, renewable energy is relevant to energy efficiency and demand-side management, as the latter two are viewed as transitional measures that can assist South Africa to make the tough transition to a green economy where renewable energy is a huge part of the energy mix. Energy efficiency and demand-side management counter the argument for more fossil-based energy as they aim to reduce demand while renewables mature and the market for them is being created. The policy framework for renewable energy is also to be found in various white papers, that's our policy papers, and in our very recent climate change white paper of 2011 that specifically provide for a renewable flagship program by government. Our Integrated Resource Plan of 2010 to 2030 was published in 2011, and it's foreseen that by 2013, our renewable energy should contribute 42% of the new additional energy capacity in South Africa. Its total share will be 9% of the total energy contribution. It's further foreseen that the contribution of gas will increase with 1% and nuclear with 50%. The contribution of coal-generated energy will have to reduce to 65% by 2030. Whether that will happen is another question. On 26 June 2012, it was announced by the Department of Energy that it's going now to procure electricity from small-scale renewable energy projects in the country. Our renewable energy is regulated mostly by our National Energy Act, our Electricity Regulation Act, and then by regulations. But it mostly deals with the fact that the minister may issue standards or issue regulations, but there is no specific act that specifically deals with renewable energy as such. What are the challenges? To achieve sustainable development, there's a need to move towards renewable energy and sustainable energy production coupled with energy efficiency. But there's also a need for government to promote and fulfill its socio-economic rights that hinge on expedited economic growth. The implementation of policies and laws that mandate renewable energy has also been hampered by the misalignment between the country's energy laws and environmental laws that promote sustainable development. The latter set of laws and policies are viewed by suspicion as obstacles to development, and recently we are also hearing it that our environmental laws is an obstacle to the introduction to renewable energy and wind farms and solar panels, etc. There's also a lack of synchronization between environmental law, energy law, and local government laws. And the contradiction between these fields of law have a particularly negative impact on how to foster pathways to sustainable energy, renewable energy. Now, some of the key principles of environmental law should inform how the development of energy policy and regulation, or should inform the development of energy policy and regulation. But there are regulatory inconsistencies in relation to other areas of laws with regard to land use planning and agriculture, and also then with regard to food security and environmental impacts. Now, the opportunities are that local government is best situated to promote small-scale renewable projects and to promote the rollout of national projects such as solar panels and wind farms, etc. And they may create better regulatory incentives to promote individual energy choices, for example. They may also be better to promote and implement voluntary projects or standards. We see a few examples there. The city of Johannesburg, for example, used gas since 1892. And they privatized their gas operations in 2000s. And since then have implemented, for example, ISO 14001 standard to use and to assist them with that. There are also various other renewable energy projects in Johannesburg. The city of Cape Town already introduced a long time ago a climate change strategy and a climate change action plan, also to reduce not only climate change action, but also to introduce renewable energy. eThekwini or Durban also has a department dealing only with climate change issues and renewable energy projects. And they also include, for example, pilot green roofs, waste to methane gas, and energy, and again, toilets. You will think the South Africans only talk about toilets and stuff. Toilets to methane gas, energy, etc. Now, in conclusion, our regulatory constraints, if considered in the context of policy and institutional barriers to renewable energy, indicate that it's not practicable at this moment to think that renewables can immediately displace our old fossil fuel-based technology. Thus, to imagine in a world which the whole of South Africa is powered by renewable energy is unthinkable in the current framework. This realization leads to thinking in terms of energy mixes, or the idea that the country should at least promote the use of all energy sources to enable a smooth and gradual transition to renewable energy sources. What's envisaged in our integrated resource plan is that South Africa is going to rely on fossil fuels until 2025. Then there's going to be a plateau period, allowing renewables to level up with non-renewables, after which there will be a sunset period where non-renewables will be phased out and renewables will gain prominence. And that's to my positive contribution. In the same context, it has been argued correctly that the call to transition to renewable energy must be concurrent by instilling energy use discipline in the minds of South Africans. Energy was initially very cheap, it became not so cheap anymore, but there should be a mindset change. And there are various tools to use and to discipline that. And one of it may be to install in industry to use voluntary mechanisms to do so, or to give them tax benefits to do so. It is important to remember that energy saved through efficient use could very well eliminate the need to construct new power plants. Thank you.
Fabulous. Excuse me, are those microphones working yet?
Yeah.
So here, my thought is that the panelists, we could all go up there and then begin a discussion on these really stimulating, fascinating presentations.
That was a good presentation.
And let's start out with the, all of us have talked enough, so why don't we start out with the participants in the audience. This gentleman there has a question.
Michael Kidd from South Africa. I think most of the panelists know that already. I've got a comment that doesn't require a response, but obviously anybody's free to respond if they want to. And it pertains to two comments that were made earlier. One a comment by Bruce to the effect that South Africa needs more energy. And I think the comment's also relevant to something that Natalie said, where she suggested, and I think I totally agree with this, that we need to move away from GDP as a measure of economic growth or economic well-being. The situation in South Africa, as I understand it, I think is based on economic presumptions that don't necessarily hold water. Three of the imperatives in South Africa at the moment clearly are poverty alleviation, economic growth, and then various other policy issues relating to energy that Wilhelmina's spoken about. Now, it seems that the argument is that poverty will be alleviated by growing the economy. The idea, presumably, that growing the economy measured by GDP, because I can't see anything in any policy document that suggests that there's any other measure that's being used, will lead to the poor being drawn out of their situation into a situation where they're not poor anymore. However, the likelihood is that if GDP grows, the benefits of that increased GDP will probably stay with the people who are already benefiting from the GDP that it is. In other words, the poor aren't going to get any trickle down, or however the economists describe it. And when we look at the situation in respect of energy, and the comment that Bruce made that South Africa needs more energy, again, there's an assumption, given the fact that there are lots of people in South Africa who don't have access to energy, which is a reality, that bringing on board Medupi and Kusile and taking out of mothballs various other power plants that are all going to burn cheap coal, and it's cheap because we look only in terms of what it costs in dollars or rands and cents to buy it, not the environmental costs of taking it out of the ground and transporting it and burning it, etc. That this increased energy will then assist the poor to improve their lot and to give them power. But it seems that most of that power will probably be required by industry and mining, which goes back to the initial premise that increasing the profits of industry and mines aren't necessarily going to help the poor. Now, it's quite interesting. I was chatting to Jan Jans, who a lot of you will know, from Holland. He says that his domestic electricity needs are almost entirely self-provided. In other words, he's almost completely independent from the grid. In our South African energy policy, and people here who may know more than I do, but I've looked into it in quite a lot of detail, it seems that most of the emphasis being placed on solar energy, for example, is looking at solar energy as a big source of power for the grid, not as individual energy provisions for individual users, particularly domestic users. Now, I don't think anybody here needs to be told that the amount of sunshine that we have in South Africa is considerably more than the amount of sun that Jan Jans has in the north of Holland. Now, if he can be almost completely free of the grid, why can't most South Africans, not only for purposes of heating water, but for all of their other domestic electricity needs, produce that by means of solar power? And that just doesn't seem to be on the policy radar whatsoever. So I question the need, or the perceived need for more energy in South Africa, particularly if that perceived need is seen as being necessary to alleviate poverty. To me, it seems that this perceived need is really just to fuel industry and mining, where most of the profits end up outside of South Africa anyway.
That's a great point. I certainly have a comment too on that, but maybe you have a comment too on it. Okay. Well, you've made a great point, and actually I didn't. Well, this is a small enough room, so okay. Well, I can. Actually, when I made that comment, I was kind of repeating the standard explanation that's given, like you know, the World Bank and the other agencies when they funded these coal plants. You can read in policy journals and this sort of thing. There's this constant refrain: "Oh, coal is cheap power, and in developing countries you need it for give more energy for the poor, and so on and so forth." But you're absolutely right, and I think in particular, since I've actually been studying this in the past couple of weeks, because as I mentioned, I'm writing a book on the World Bank's environmental policies and lendings over the past 20 years. I've been looking at the climate energy issues, and of course the rationale for some of these giant coal plants that have been financed not just in South Africa but in India. Tata Munda is a famous case, another 4,000 megawatt coal plant that the bank financed with hundreds of millions of dollars of loans. The rationale this will help the poor is, of course, is false. In the case of Tata Munda in India, that was a 4,000 megawatt plant. And again, the power would go to the big cities and to industry. Only 0.1% of the power was targeted to actually give poorer people new energy access, and that was in India. In South Africa, many non-governmental groups in South Africa made the point at the time of the controversy over the World Bank loans for Medupi, that I think there was something like 10 million people in South Africa that had no access to energy and so on, and they made the point that the power from Medupi would go to, as you pointed out, mining and energy-intensive industries, a lot of the multinational corporations, and that at least in the past there had been a apartheid-era even accord with the pricing accord for power with a number of these corporations, which gave them grotesquely subsidized power, something about 1/4 or something what consumers, individual consumers, had to pay. So that was the point that increased energy generation doesn't mean increased energy access for the poor. There are a number of studies that show this is very important. And what you see is that with the pattern of international multilateral bank lending for energy generation around the world and so on, all in the name of the poor and the Millennium Development Goals and so on. In reality, there's a big disconnect between what they're financing and actually increasing access to the poor, for the poor. And again, many are increasingly making the point, as you made, that actually for most of the people, there's 1.4 billion people on the planet that have no access to electricity whatsoever. They're off-grid, they have nothing. Many of these people live in rural areas in South Asia and in Sub-Saharan Africa, and in many cases, off-grid, smaller scale solutions. It can be solar, it can be biogas, what have you. Can be actually less expensive than linking them up with the grid to some giant coal plant that's 500 or 1,000 kilometers away or what have you. So you're absolutely right, and I think in the discussion of the Millennium Development Goals and international aid and finance for energy, the need for finance for climate mitigation and adaptation in developing countries and that kind, it all plays into this whole energy question, and a false dichotomy has been built up. Totally, it's a bogus dichotomy between energy access for the poor and the increased investments in supposedly cheap fossil fuels and so on. But unfortunately, I have to add that this myth, it's an easy one to propagate. In Washington and elsewhere, you have these people in think tanks are constantly reiterating this argument, oh, you can't deprive poor people in India or Africa or anywhere else of access to power by insisting that their governments build more expensive renewable energy. If you read the latest issue of Foreign Affairs, which is kind of the leading foreign policy journal, the establishment foreign policy journal in the U.S., has an execrable article in it by a guy at Stanford who's a kind of a specialist in coal, who repeats these same arguments, that we need more investment from multilateral development banks and international aid agencies in coal. It's an article on the need for more coal, but make it more efficient, supercritical or ultra-critical, which means it's 15 or 20% more efficient, but you're still, coal is still by far, even the more efficient plants are still the biggest sources by far per unit of energy generated of greenhouse gases and so. So thank you very much for that comment, because I think it's on a fundamental debate and the whole issue of sustainable development and energy finance. Well, another either comment or question? Hi. Yeah.
Hi, I'm Michelle Song and work at the law school here as a lawyer with the clinical law program. I wanted to ask Dr. Ko and anyone else who wanted to contribute just about the litigation you were talking about in Nigeria and just generally litigation in the extractive industry that affects indigenous communities. I was interested in your thoughts as to whether you feel the litigation is best in the country where the harm occurs, like in Nigeria, or at the international level, international fora, or in the U.S. we have the Alien Tort Statute, which is currently under consideration by the Supreme Court. But just generally your thoughts on Nigeria's experience with this and other countries.
I mean, with regards to Nigeria, I think the situation when Nigeria was under military rule was quite different, because the legal setting then was quite obvious that justice could not be done in Nigeria, mostly, and that gave the opportunity to like Shell and Liwa and the Chevron case, both in the U.S. Of course, the Chevron case didn't go. They weren't successful with that, and with Liwa and Shell, they settled out of court, of course. Right now, it will be increasingly difficult because to do foreign litigation, because with democracy in Nigeria, access to the courts increased. It becomes more difficult to show that the legal system will deny justice. But having said so, what again litigants have been doing is to look at home countries of these oil companies and where they have offices to see what the now local laws in foreign countries have. In other words, they are now using local laws of foreign countries as against international law, right, like the African Charter or what have you, to as the basis for litigation. Now, the advantage in this sort of thing is because you're approaching a more developed system where judges are more, I wouldn't say sympathetic, but they are more aware of these environmental issues than Nigerian judges. Then you tend to believe that it's going to be a fair opportunity at justice. But having said so, again, there are difficulties. I mean, you can imagine the Wiwa case. You can imagine how much money they need to fly out the plaintiffs, witnesses, language issues, cultural issues. I mean, these are people who live in the creeks and you're bringing them to the US. Okay, a lot of them said they weren't going to make the trip. So there are these difficulties that are also involved, But I think that it's definitely an avenue that can contribute to the jurisprudence in Nigeria, because if we have these cases decided, then of course they can be cited as precedents, or at least as of some measure of authority in local cases. I was talking to Ben Amunwa last week, who's with Platform, one of the very active NGOs in the Delta, who had a program like this. And you know, I sort of challenged him. I said, Ben, what's going on? You guys seem to be a bit more less active now that, you know, there's democracy. And he said, well, Rooks, you know, it's not easy because, you know, things have changed. And I get the feeling that perhaps maybe because there was this illegitimate government, okay, that took part in these environmental injustices, was like fighting the government and using that as the reason. But these days it seems as if they've sort of reduced in number, you know. So to answer your question directly, I think yes, at both levels, both locally and internationally, there are both avenues that can be used, have the advantages, of course, have the difficulties at both levels. One of which, of course, includes the fact that with international issues, you sort of write opinions, which the judge then makes his decisions. And like I said in my example, this Sankusi has been, you know, utterly ridiculous with his understanding and interpretation of Nigerian law. So if it was, for example, a typical Nigerian lawyer who's not done research in that area, would probably say, I mean, the Netherlands judge would take that as the position when it isn't. So there are, you know, pros and cons, but obviously a lot to be achieved from both sources.
This gentleman here.
Yeah, my name is Carey Olinde. I'm doing a PhD in environmental law at the University of KwaZulu-Natal. Really, the way I'm looking at this matter has to do with what are the institutional safeguards and frameworks by which this kind of environmental injustice can be addressed. I say, looking at the Nigerian context, we're still very far away from, you know, strengthening the institutions that could really address environmental injustice with regards to the activities of oil companies and the victims of oil pollution or oil-related activities. If you look at, we're coming from our background of military rule. In those days, any case in the court could be terminated by a decree, and then the decree is made to be supreme, that even the courts cannot inquire into what the case is all about or to look into it. But now the constitution is there, we have access to the courts, the constitution is supreme over decrees and over laws made by military regimes. But even then, we still have the mechanisms, the enforcement mechanisms that are very weak. Institutions are not enforced. And that's why some of these litigants prefer to come to the United States to test their case there. And if you remember recently the case of Bowoto and Chevron, even now as it is, the Supreme Court is here to come up with a decision as to whether, you know, thoughts that happened in a foreign country could be successfully litigated in the United States. And the Supreme Court has postponed decision on the matter. And we're still waiting to see what they're going to say by October. But where does it leave the litigants? Because they spend a lot of money to address an injustice which has not yet been redressed. The environment is still there, worse than before. And even the money they spend it, they're not recovering anything from the money. And so we need to really look at the institutional frameworks and see how we can use that to strengthen the system, and see how we can use that to also help the litigants to seek redress in their home countries. Yeah, it's good news for lawyers, because if lawyers get judgment in US courts, they can look for assets of these oil companies and attach them and make money. But even if they make the money, what about the people who are suffering the injustice there? And how does this help them? So these are the things and these are the angles at which I'm looking at the whole matter. And I think that we feel still far away from getting to the safe haven as far as this matter is concerned.
Can I add to that? Because there was a case where a group of people in South Africa also went to the UK to claim damages for asbestos-related diseases that they've got. And they are still haven't been paid out. The court gave judgment, and many of the people have died since, and they still haven't received the money. So there's really also can help to go there. It served their case to go to a UK court, because the tort law is different than in South Africa. But in the end, they didn't receive the money or in time.
Well, you've raised I think almost a critical underlying issue in all discussions of environmental law and environmental justice and so on. It was touched upon in the plenary session about that at Rio there seems to have been some realization that there are plenty of laws and international conventions and so on, and many countries have on their books good laws in general and good environmental legislation, but the issue is of governance, capacity, and local institutions. And when there's a lack thereof, that often translates, first of all, into corruption. And so I think sometimes in our discussions about environmental law, we kind of forget that it's all a bit hollow if you don't have if you're not aware of thinking about the implementation, governance, institutional capacity issue, and building it up at the local and national level. And along those lines, I guess I'd sort of like to ask, well, start with Brooks. I mean, but in terms of you described some interesting legislation, which is kind of thought-provoking about which would seem to be progress. But how do you think the improvements in institutional capacity and governance and so on is there progress occurring in Nigeria? Are there some signs of hope? Of course, every country has this challenge. It's in varying degrees in every country. In the U.S., we have corruption and governance issues too. So,
I mean, with regards to institutions, I guess we can all sit back and say institutions are weak, institutions are not perfect, and all the likes. But I think we are the institutions. Okay, and my own thinking is that until we begin to affect those institutions, they'll remain as they are. In other words, if you think you're not getting, say, judgment from cases, bring more cases. Okay, I know it may sound somewhat short-sighted, but if you have litigation against Shell, for instance, and you get judgment, and for some reason you think Shell hasn't paid out, I mean, I don't think within Nigeria, I haven't heard of a situation where the court has ordered something and Shell has refused it. The worst they will do is appeal it, and the appeal files get lost. But I don't think there's been a time when a court has actually ordered payment of compensation or stuff like that, and they've refused to. The other thing I've also sort of talked to a few lawyers about in the last couple of months is, I've said we also need to start, I mean, this is with regards to Delta in particular, we need to also start reconceptualizing how we actually bring cases to court. We've relied so much on the law of tort, which is all about compensation, and we always think, what do we get from it? And if we're actually talking about the environment, is the environment about compensation, or is the environment about restoration, or at least preventing this pollution from taking place? So if you've gotten to a point where you know that you can litigate and get compensation, then let's also start looking and thinking about how we can get orders off the court, such that the barriers of operation of these companies are increased. In other words, you would know, for instance, that it's a common thing in Nigeria that there are two different levels of operations for Shell. Nigeria, the one, and then anywhere outside Nigeria, a different one. So if that's the case, I think we have allowed it because all we do in litigation is go to court for ask for compensation. So the laws remain the same. So why don't we start challenging those laws? And then when courts say these laws are not as they ought to be, then something happens. And then there's a higher threshold. And then you are forcing the institution, because the institutions can only interpret the laws you have. So if your laws are ineffectual, which is my point, it's all about law. Laws actually create institutions. Institutions do not act in a vacuum. So if you have the laws, then you can twist the arm of whatever institutions to enforce those laws. And in practice, what that means is the threshold of operation of these companies increases. And that's my argument with Bimre's case. I'm sure you'll be familiar with Bimre's case. Briefly, that's a case regarding gas flaring. The plaintiffs won at the High Court because the judge said, well, yes, gas flaring is unconstitutional, it's bad environmentally, and ordered that the government basically goes back and does something about the law. Shell, of course, has appealed. And what has happened is, since the appeal was put in, nothing has happened. The facts are lost. The judge got transferred to the north of the country, which is punishment. So what I'm saying in essence is, these things happen, yes, but the only way to change these institutions is then to start thinking about how we can use existing laws, look for methods to use the existing laws to affect the institutions, and then it's a process that won't take place in a day, 10 years maybe, but I think that's my take on it, really.
Yeah, I think I would rather differ with you on that area, that if you file a case and it's not working, you file other cases. You are just trying to use the same method that is not working, and you end up cluttering the cases in the courts, and that's not what the litigants want. They want justice. They want environmental justice. They want redress. The oil that has been spilled, there's a need to clean up the place. The mechanism for cleanup, even though it's there in the books, they are not enforced. The oil companies, they know that these problems are there, but it costs them so much to do that, and they want to avoid that. Is the government coming in to do the cleanup? And if they do so, how do they recover the costs?
Sorry, before you go on, who owns Shell?
Shell is a multinational company.
No.
Owned by shareholders.
No. Go and do a bit more research. Shell, SPDC.
There is SPDC. That's different from Shell.
Yeah, absolutely.
Shell as a multinational company is different from SPDC,
absolutely,
which is an agency of government and that has a joint venture with Shell.
Absolutely.
So there are two different levels of operation.
The point I'm trying to make to you is, you're saying the government is to do cleanups. No government would do any cleanup, even in the US, if no one is looking up to them to do anything. All governments are irresponsible to the extent that their citizens are responsible. And when I say people should litigate, I'm not saying there's litigation and then for the fun of it you litigate. What I'm saying is they have, and I'm trying to mention that as lawyers we have to keep testing and keep thinking. Talk to yourselves, NGOs, practitioners, lawyers. You have to keep thinking of new ways. Bimre was a completely new way of litigation. Okay? So are we going to say, oh, because cases like Isaiah and Shell or Farah and Shell had recorded successes, we're going to keep litigating on law of torts? That means there's never ever going to be hope that you're going to get things like environmental remediation. You're never going to get cleanups. All you're going to get is compensation. So when I talk about litigating, I'm not saying litigate over the same old, tired reason. I'm saying you need to keep litigating and thinking up new ideas, new ways of doing things. So perhaps you just, got me wrong.
Let's fascinating. I'm glad we have a bit of a fiery discussion here. It's time now. Why don't we maybe one last question? If anyone from the audience has one last question, they're really just burning to ask. Yes, this lady in the back.
Yes, I have a comment that I would
comment.
Yes, and maybe an opinion as well for Natalie. First of all, thank you for a very interesting and informative presentation. I really enjoyed it. With reference to the social component of sustainable development being human beings, Do you think that it might be possible to use human security as an indicator to measure the success or non-success of the green economy?
I think it's a great question, and I think the whole human security, food security, that way of looking, that lens through which to look at social issues, is very powerful in the context that we're operating in right now. So, yes, I think it is. I think it would be actually quite a useful way to look at it, and maybe something I can think about in the paper. I think though that we have to be. I live in North America, and I'm sort of a little bit tainted by the sort of culture of fear that has been used in this area, and sort of a fear-based approach. And I see sometimes the push towards, sort of some of the human security issues in that context, because I'm colored by my personal context in North America. But I think it's a very useful way to look at it in a much broader way.
No. Well, time has come. Certainly all who want to leave, should we leave? I don't know if there's any appetite to continue the discussion for another 5 minutes or an hour, or do we feel that we should quit while we're ahead?
I'm happy to stay after if people have questions,
Yeah.
but I think at the end of the day.
Yeah. Well, this room appears to be empty, so my suggestion is everyone who needs to take off or wants to take off should take off, and we could stay here for another 5 or 8 minutes and for a smaller group, and if anyone has further questions and wants to discuss anything, maybe leave by around 4:30. So that's good. I actually had one last question for Wilhelmine. Talking about capacity and governance and so on. What do you think? I mean, all these initiatives in South Africa on energy efficiency sound very interesting, but what's the state of the capacity of South African institutions and governments to really implement all this? How do you?
Our Department of Energy is very energetic.
Okay, well, that's good. Okay, as it should be.
So, and the municipalities started to introduce a lot of these measures too. So the large metropoles, Johannesburg, Durban, Cape Town, the big cities also introduce it. So I think at that stage it's good. It's at the local level, it's in the small cities, small towns, and it's in the poorer areas where we will have difficulties to implement it. And I think we will have to work in industry on voluntary mechanisms to push them to do that.
So you're relatively optimistic.
Yeah.
Oh, that's good. Okay. Okay. Well, we can.